Welcome to Beyond Bare Act, where law is explained in context, beyond the wording of the statute. For our first series, we are beginning with the Information Technology Act 2000. Why begin here? Because digital life now shapes almost everything we do. Receiving official documents, making payments, entering agreements, using government portals, sharing content and relying on connected services. Each of these actions raises a legal question. What gives an electronic record legal recognition? What happens when technology is used for deception or unauthorised access? And how is responsibility divided among users, platforms and the state? That makes the IT Act relevant not only to lawyers and technology companies, but to students, consumers, businesses, public officials, and practically everyone using a connected device. Yet it is often described simply as India's cybercrime law. That is incomplete. The Act began by making lawful electronic activity legally possible and later expanded into cyber offences, cybersecurity, government powers, and intermediary responsibility. In this episode, we will build that framework from the beginning and understand where the IT Act fits in India's digital world today. Let us start with a simple idea. Every digital action has a technological side, but many of them also have a legal side. Think about an ordinary morning. You receive a document by email, you pay a bill through an app, you book a ticket without printing anything, you submit a form to a government portal, and then perhaps you receive a message that looks genuine but is actually designed to steal your identity. We perform these actions almost automatically, yet each one raises a different legal question. Can an electronic document be legally recognised? Can a contract be formed without paper or a handwritten signature? What happens when someone enters a computer system without permission? Who must respond when unlawful material is uploaded to an online platform? And can Indian law apply when the person responsible is sitting outside India? The principal legislation connecting many of these questions is the Information Technology Act 2000, commonly called the IT Act. In this first episode, we will not memorise a list of sections. We will understand why the IT Act was needed, what it was originally designed to accomplish, how its role later expanded, and why a law enacted in the year 2000 remains central to India's digital life in 2026. To understand the Act, we must first return to the problem it was trying to solve. Traditional legal systems were built around paper. Laws frequently expected information to be written, a document to be signed, an original to be produced, or a record to be physically retained. Electronic communication challenged those assumptions. An email did not look like a paper letter. A digital record could be copied perfectly. Two parties could complete a transaction without meeting, exchanging physical documents, or using ink. Commerce was becoming faster than the legal framework supporting it. The basic challenge was therefore not simply how to punish hackers, it was more foundational. How could the law give reliable legal recognition to transactions conducted electronically? This was not an Indian problem alone. Electronic commerce crossed national boundaries, while domestic legal systems still depended heavily on paper. In 1996, the United Nations Commission on International Trade Law, UNCITRAL, adopted its model law on electronic commerce. A model law is not automatically binding legislation. It is a framework that countries may use while designing their own laws. Its influential idea was functional equivalence. Electronic communication did not need to imitate paper in every physical detail. The law could instead ask whether an electronic method performed the necessary legal function. For example, whether information remained accessible, whether a person could be identified, or whether the integrity of a record could be assessed. India's IT Act was enacted against this international background. Parliament enacted the Information Technology Act in 2000, and it received presidential assent on the 9th of June that year. Its long title tells us what the legislation was principally intended to do. It sought to provide legal recognition to transactions carried out through electronic data interchange and other forms of electronic communication. It also sought to facilitate the electronic filing of documents with government agencies. Put simply, the Act helped build legal trust in a paperless environment. This is why it is misleading to introduce the IT Act only as India's cybercrime law. Cyber offences are important, but they are only one part of a much larger legal structure. The Act also deals with electronic records, electronic signatures, electronic governance, attribution and dispatch of electronic records, certifying authorities, civil contraventions, criminal offences, government powers, protected systems, incident response, and intermediary liability. The first pillar is legal recognition. Section 4 addresses electronic records. In simple terms, where a law requires information to be in writing, typewritten, or printed, that requirement may be satisfied by information made available in an electronic form, provided it remains accessible for later reference. This does not mean that every digital message is automatically genuine, enforceable, or factually correct. Legal recognition is different from proof. A disputed record may still require authentication and evidence, but Section 4 removes the basic obstacle that an electronic record should be rejected merely because it is electronic. The second pillar is electronic authentication. The Act gives legal recognition to electronic signatures and contains a specific framework for digital signatures. These expressions must not be used carelessly. A scanned image of a handwritten signature, an OTP-based approval, and a cryptographic digital signature are not technically identical. Their legal effect depends on the applicable law, the method used, and the surrounding facts. A digital signature under the Act uses an asymmetric cryptographic system and a hash function. In beginner's language, the method helps connect a signer to an electronic record and helps reveal whether that record was altered after signing. The Act also establishes a regulatory structure involving the controller of certifying authorities, licensed certifying authorities, and electronic signature certificates. We will unpack that technology without assuming any knowledge of cryptography in a later episode. The third pillar is electronic governance and electronic transactions. The Act enables governments and public authorities to use electronic records for specified functions, including filing, issue, and retention. But there is an important qualification. The Act does not give every person an unrestricted right to insist that every government department must accept every document electronically. The applicable legal and administrative framework still matters. Section 10 A also confirms that a contract should not be regarded as unenforceable merely because proposals, acceptances, or their revocation were communicated electronically. Again, this does not validate every online arrangement. The ordinary requirements of contract law, such as competent parties, free consent, lawful consideration, and lawful object, remain relevant. The IT Act removes the objection based only on the electronic mode. But the digital environment changed rapidly after 2000. Computers were no longer used mainly for office records and electronic commerce. Communication devices became personal. Networks became interconnected. Platforms began hosting enormous quantities of user-generated content, and cyber attacks acquired the capacity to affect individuals, businesses, and critical infrastructure. The Information Technology Amendment Act, 2008 substantially expanded the framework. Among other changes, it introduced or revised provisions concerning identity theft, cheating by personation through computer resources, violation of privacy, cyber-terrorism, interception, blocking, critical information infrastructure, CERT-in, and intermediary safe harbour. The amended framework came into force through notification in 2009. This expansion explains why the IT Act now operates simultaneously as an electronic transactions law, a cybercrime law, a cybersecurity law, and part of India's platform governance framework. One distinction will appear throughout this series. Not every unauthorised computer-related act has exactly the same legal character. Section 43 identifies several acts involving a computer, computer system, or computer network when they are done without permission. For example, accessing a system, copying data, introducing a computer contaminant, disrupting a system, or denying authorised access. Section 66 connects criminal punishment to acts referred to in Section 43 when they are committed dishonestly or fraudulently. That mental element matters. A technical event, a civil contravention, and a criminal offence must not be treated as interchangeable expressions. In later episodes, we will apply this distinction to insiders, students, security researchers, phishing operations, and unauthorised access. The Act also gives the central government and authorised agencies significant powers in specified circumstances. Section 69 concerns interception, monitoring, and decryption. Section 69A concerns blocking public access to information through a computer resource. Section 69B concerns monitoring and collection of traffic data or information for cybersecurity. These powers are not one single power, and they do not operate through identical grounds or procedures. Because they can affect privacy and freedom of expression, they must also be understood alongside constitutional principles, procedural safeguards, and judicial review. A responsible explanation must therefore examine both sides. The statutory objective of protecting legitimate public interests and the legal requirement that public power remain authorised, limited, and accountable. Then comes one of the most important questions of the platform age. Is an online service automatically liable for everything its users post? Section 79 provides conditional protection, often called safe harbour, to an intermediary for certain third-party information, data, or communication links. An intermediary is generally a service that receives, stores, transmits, or provides services concerning electronic records on behalf of another person. Depending on its function, the term can include internet service providers, web hosting services, online marketplaces, search engines, and social media platforms. Safe harbour is not blanket immunity. Its availability depends on the statutory conditions and legally applicable due diligence requirements. Judicial interpretation, especially the Supreme Court's decision in Shreya Singhal versus Union of India, is essential to understanding how actual knowledge and takedown obligations operate. The IT Act is not frozen in the year 2000. Its operation is affected by amendments, rules, notifications, constitutional decisions, and neighbouring legislation. The Information Technology Intermediary, Guidelines and Digital Media Ethics Code. Rules 2021 created detailed obligations for different categories of intermediaries and also addressed digital news and online curated content. They have subsequently been amended. In February 2026, amendments dealing with synthetically generated information came into force. They introduced specific provisions concerning certain artificially or algorithmically created or altered audio, visual, and audio-visual information. This is directly relevant to deepfakes. But the exact definition, exclusions, and obligations matter. Not every edited image and not every piece of AI-generated text should automatically be described as regulated synthetic content under those provisions. India's data protection architecture is also changing. The Digital Personal Data Protection Act 2023 provides for the eventual omission of Section 43A of the IT Act. But that omission is not yet in force as of 26th July 2026. Under the November 2025 commencement notification, Section 44, subsection 2, which carries that amendment, is scheduled to commence 18 months after publication. Until then, Section 43A remains part of the current IT Act framework. We must therefore check commencement dates before claiming that every provision is already operational. Enactment, notification, and commencement are different legal events. Finally, the IT Act does not govern the digital world alone. A single online incident may also involve the Constitution, the Bharatiya Nyaya Sanhita, the Bharatiya Sakshya Adhiniyam, contract and consumer law, intellectual property law, the POCASO Act, or the Data Protection Framework. For example, the IT Act may define a computer-related offence, while the Bharatiya Sakshya Adhiniyam governs important questions concerning proof of the electronic record in court. A deepfake may engage platform obligations, but it may also implicate privacy, impersonation, sexual offence, intellectual property, or other laws depending on its content and use. Good cyber law analysis begins by identifying the conduct, the actors, and the harm, before selecting the legal provision. We can now see the IT Act as a legal architecture rather than a random collection of cyber offences. It gave electronic records and signatures legal recognition. It enabled electronic governance and contracting. It created civil and criminal consequences for specified computer-related conduct. And, as technology evolved, it became central to cybersecurity, governmental powers, and platform accountability. But before we apply any of these provisions, we must learn the language of the Act. Is your smartphone a computer resource? What is the legal difference between data and information? Who is an intermediary? And when can Indian law apply to conduct occurring outside India? Those questions form Episode 2. Does the IT Act apply to you? Scope, definitions, and extraterritorial reach. This is beyond bare act. Law in context, power in practice.